Hi, myself Shivangi Lohomi. I'm a legal intern at LEXIS and Company. I'm from Yashwantrao Chavan Law College, Pune, Maharashtra. Today my topic is Doctrine of Colorable Legislation. Colorable legislation theory implies only a restriction of the legislature's law-making power. While the government purports to act within its authority, it appears to realize, but in fact, it has transgressed certain powers. So, the doctrine becomes valid whenever a statute tries to do what it cannot do, specifically in an indirect manner. In India, parliamentary and state legislatures' legislative powers are delegated by Article 246 and allocated in the 7th schedule of Indian Constitution by list 1, 2 and 3. Parliament has the power to legislate on any of the list 2 matters, and Parliament and the state legislatures both have the power to make laws on any of the list 3 matters, and the residual power of regulation vested on Parliament by way of Article 248 and 97, List 1. It is a matter of how legislative power must be exercised between the centre and states, or it relies only on the relationships between them to create some legislation or the legitimacy of that rule. The main point is that the government with punitive authority cannot invade the field of competency. It's called the constitutional scam. To understand this concept in much better way, one of the most cogent and lucid explanation relating to this doctrine was given in case of K.C. Gajapati Narayan Deo and other versus the state of Odisha. The constitution of a state distributes the legislative powers amongst different bodies which have to act within their respective spheres marked out by specific legislative entries, or if there are limitations on the legislative authority in the shape of fundamental rights, questions do arise as to whether the legislature in a particular case has or has not, in respect to the subject matter of the statute or in the method of enacting it, transgressed the limits of its constitutional powers. Case law. In case of Shri Prithvi Cotton Mills versus Broch Municipality, the CJ granted legislative competence and stated that it is not sufficient to merely declare that the court's decision will not bind, as it is equivalent to reversing the decision in the usage of judicial power, which the legislature does not possess. A court's decision should always bind in all situations unless the conditions are fundamentally altered. In conclusion, when the legislature had the power to legislate on any issue, it had all the ancillary and incidental power to make the law efficient. So, the colorable legislation is needed to fix the legislative accountability with reference to some modification in legislative functions. There are some limitations of colorable legislation. Doctrine does not extend to subordinate legislation either. Colorable law theory does not require any doubt on the part of legislature about bona fide or mala fides. If a legislature has the power to make legislation on a particular subject, it also has the power to make the law successful. When discussed above, legislature's transgression of constitutional power may be proprietary, manifest or actual, but may also be veiled, concealed and indirect, and the term colorable legislation applies only to this latter class of situations. This video doesn't solicit any types of promotion or advertisements as per the guidelines of Bar Council of India, and the sole purpose of this video is for education purposes only. Please like, share and comment on my video, and do subscribe this channel. Thank you so much.